I'm sorry, my sound was off. Let me start this all over again. Wow. I'm really sorry about that. I will cut off that part at the beginning of this video. But yeah, I apologize for that. Yá'át'ééh, my relatives. Hello, this is Mark Charles. I am honored to be with you today, and I want to discuss the recent Supreme Court case that was decided a few days ago, about a week and a half ago. It's Castro versus Huerta, Oklahoma versus Castro-Huerta. And it's a decision that really broke with historical precedent regarding uh, law governing Native nations and Native peoples, indigenous peoples, and it really worked to redefine the relationship that states have in their jurisdiction over Indian reservations and Native lands. And it is a law that a lot of people are deeply troubled by. And I have been slow to comment on it publicly because I wanted to take time to read the opinion and to have a good sense of what is going on with this court case. And so I decided to wait a week before I responded to it. But I'm grateful that you could join me for the second cup of coffee. And I want to begin, as I always do, by acknowledge that I'm speaking to you from what's now known as Washington, D.C., but these are the traditional lands of the Piscataway. And I want to honor the Piscataway as the host people of these lands. I want to thank them for their stewardship of these lands. And I want to just state how humbled I am to be living on these lands today. So let me go ahead and get started here. Again, I'm sorry for the silence that began this video. I didn't know I had my mic off. But Andrea, great to see you. Terry, good to have you here. Mary, Yá'át'ééh, Elizabeth, thanks for joining today. I see there's a lot of people. Shantina, Yá'át'ééh, Jim, thanks for joining. Yeah, so anyway, let's talk about this Supreme Court case. I'm going to share a few articles with you. The first is, again, just a general article about the case. It was written by AP News, and it's titled Experts Say the U.S. Court Fractures Decades of Native American Law. And this article will give you an understanding of what the Supreme Court decided. Basically, I'll just read a paragraph from this. It says a U.S. Supreme Court ruling expanded state authority to prosecute some crimes on Native American land is fracturing decades of law built around the hard-fought principle that tribes have the right to govern themselves on their own territory, legal experts say. The ruling Wednesday is a marked departure from federal Indian law and veers from the push to increase tribal abilities to prosecute all crimes on reservation, regardless of who is involved. It also casts tribes as parts of states rather than the sovereign nations they are, infuriating many across Indian country. I'm also going to share with you this story by Indianz, our Indians, which just gives a very good Native perspective on this case. And then I want to share with you a story. Let me pull this one up too. This is from the Cherokee news website. Anadisgoi, I think is how you say it, although I could be mispronouncing that. I apologize if you are Cherokee and I did not pronounce that correctly. But let me share this story with you. And this gives the statement of the Cherokee Nation principal chief on this decision. And this was published on their news website. Anadisgoi is the website. And he wrote, with today's decision, the U.S. Supreme Court ruled against legal precedent and the basic principles of congressional authority in Indian law. During arguments, Justice Gorsuch wrote, if the court would wilt today because of a social media campaign, it is unfortunate that the answer appears to be yes. The dissent today did not mince words. The court failed in its duty to honor this nation's promise. It defied congressional statutes and accepted the lawless disregard of the Cherokee's sovereignty. And then finally, I'm going to share with you the actual opinion. And this is in a PDF article or PDF file from the Supreme Court. And this is the opinion written by Justice Brett Kavanaugh and the dissent written by Justice Neil Gorsuch, both of whom were appointees by Donald Trump. And yet they had a very striking, well, in some senses, a very different opinion of Indian law, and in other senses, they had they agreed on some of the basic foundations of Indian law. And that's what I want to talk about today. So in regards to this case, if you remember, it was 2 years ago, there was a Supreme Court case, McGirt versus the state of Oklahoma, where a Native man was convicted of a crime committed against another Native man. That crime was committed in Tulsa, and it was tried in a state court. McGirt was the person who was convicted, and he appealed his decision. He appealed his conviction because he said he was tried in the wrong court. Based on treaty, Tulsa and most of eastern Oklahoma was still reservation land, he said, and therefore he should have been tried in federal court because, again, according to precedent in Indian law, federal courts have jurisdictions over crimes committed by natives against other natives on Indian reservations. And so that case went all the way, and he was convicted of a crime in Tulsa. And the state of Oklahoma fought that because they said, we've never treated Tulsa as reservation land. And the courts have decided it wasn't reservation land. And so therefore, it should be tried in state court. And McGirt won. Oklahoma lost that case when it finally reached the Supreme Court. And there was a lot of celebration within Indian country because essentially it said, for judicial purposes, most of eastern Oklahoma, about 43% of the state, was now reservation land with legal jurisdiction falling to the federal government. And so this case that went through the Supreme Court, which was Oklahoma versus Castro-Huerta, this case involved a non-native who committed a crime on the reservation, and to find out who had jurisdiction over this case. And if you read the syllabus of this case, and I'm actually going to just bring this up right now. If you read the syllabus of this case, or actually, I won't even go to the syllabus. I'll go to, let me bring up the syllabus here. Let me share this with you. So if we look at the case here, and this of course is the PDF of the opinion. And when you read the syllabus, which is not the legal opinion, it's basically a summary by, I think, a court reporter, kind of summarizing the case for the ability to read it. We'll just go to the ending argument in the syllabus. This is the final argument regarding pages 21 to 25 of the opinion. It says, this court has long held that Indian country is a part of a state, not separate from it. Under the Constitution, states have jurisdiction to prosecute crimes within their territory except when preempted by federal law or by principles of tribal self-government. The default is that states have criminal jurisdiction in Indian country unless that jurisdiction is preempted, and that jurisdiction has not been preempted here. And they also argue, if you look up above, here the exercise of states' jurisdiction would not infringe on tribal self-government, and because a state's jurisdiction is concurrent with federal jurisdiction, a state prosecution would not preclude an earlier or later federal prosecution. So basically, what they're arguing here is that Native nations, Indian reservations, fall under the jurisdiction, or states have a concurrent jurisdiction with the federal government over Indian lands, over reservation lands on those states. And the precedent for that opinion actually goes back to the early 1800s, 1830s. And one of the primary cases, which actually Neil Gorsuch brings up very early on in his dissent. He actually starts his dissent with that, and this is right here. Let me find the start of his dissent. Let me go up a little bit. In his dissent, Neil Gorsuch references a case from the 1830s, which was Worcester versus the state of Georgia. Now, this state, or this case, essentially established, I'm going to read a summary of this on a site called oyez.org, which gives summary of cases as well as opinions of the Supreme Court. It said, and this is the summary, and I'll put this into, let me put this into the comments here. So if you want to bring it up, you can look at it. Let me put this in here. It says, in an opinion delivered by Chief Justice John Marshall, the court held that the Georgia Act, under which Worcester was prosecuted, violated the Constitution, treaties, and laws of the United States, noting that the treaties and laws of the United States contemplate the Indian Territory as completely separated from that of the states, and provide that all intercourse with them shall be carried on exclusively by the government of the Union, Chief Justice Marshall argued. The Cherokee Nation, let me just show this. The Cherokee Nation then is a distinct community occupying its own territory in which laws of Georgia can have no force. The whole intercourse between the United States and this nation is by our Constitution and laws vested in the government of the United States. The Georgia Act thus interfered with the federal government's authority and was unconstitutional. Justice Henry Baldwin dissented for procedural reasons and on the merits. So this case in 1831, I think it was the opinion came out in 1832, basically said that Native nations are treated as separate from states, and they are governed, jurisdiction over them falls to the federal government and to the Constitution, not to the states. And this has begun building the precedent, the foundation of Indian law, and even creating the idea of Indian sovereignty in our court system for a very long time. Now, and so this is when people are saying it's breaking precedent, they are talking mostly about this Georgia versus Worcester case. But again, you have to remember, right? Indian law is based on the Doctrine of Discovery. It's based on the notion, the legal understanding that natives are savages and do not have full rights to their land. This is what's written in the Declaration of Independence. This is why natives are excluded from the Constitution, right? Because the basis of the founding of this nation was on the idea that discovery is what gave title to the land. And natives were savages, so we were merely occupants of the land. This is the basis of all Indian law. And so while Georgia versus Worcester does argue and conclude that there is a separation between what a state is and what a reservation is, and the reservation is under the jurisdiction of the Constitution and the government, and the Constitution again states, right, that treaties are the supreme law of the land. We have to remember that beneath that level is the doctrine of discovery. And so if we go back and actually read the opinion in Worcester versus Georgia, and I brought that up here. So this is the opinion of the Worcester versus or Georgia versus Worcester versus Georgia opinion decided in 1832. And I just did a search for the word discovery, right? We find in this opinion that discovery is actually referenced 11 times in this opinion. And savages referenced 6 times in this opinion. Right? This opinion was written by John Marshall. And one thing, even though John Marshall was absolutely a white supremacist and a racist, I appreciated that he was so clear and upfront about his beliefs and wrote them directly into his opinions. He didn't try to mince words, right? He called native savages. He based his precedent on the understanding of discovery. And in this Worcester versus Georgia, yes, the precedent that tribes are separate from states, but it still argues that the right of discovery is what is the foundation for that. And the natives are savages. Again, he acknowledges in the process of becoming civilized. But again, this opinion is not like, it's not this great native nations are sovereign. It still has the understanding that we are absolutely domestic dependents. We're inferior, subhuman people. And that the U.S. inherited the right of discovery through the Revolutionary War from Great Britain. And so let's, again, most people who are decrying the injustice of this opinion, they're decrying this understanding that natives have a sense of sovereignty over their own lands. Again, like your teenage child has sovereignty over their bedroom. But you have to understand, even that understanding of whatever sovereignty native nations have is based on the legal understanding that the right of discovery falls to white European, now Americans, and that natives are essentially savages, unable to fully govern ourselves. So it's a very limited understanding of sovereignty. But even that limited understanding of sovereignty is what had become precedent in our nation over the past 150 years or so, almost 200 years. And that's what this opinion that came out last week was reversing now. It was saying that not only, yes, we have a diminished ability to be sovereign, but it's even further diminished because actually states are sovereign over our lands that reside within those states. So I want to go through this opinion. I brought it up here on my site, and I shared the link with you. And I want to just look at some key cases throughout the opinion. And these are kind of my first impressions. One of the reasons I delayed this live stream is because I started reading some of the cases that were referenced to find out what are they basing their precedent on, and this is, again, if you ever want to get depressed regarding Indian law, read precedent written even today based on cases in the past, because again, it all eventually goes back to the doctrine of discovery and natives are savages. But you can just see over the years and over the decades and over the centuries how the United States is using this foundation of the right of discovery and natives are savages and not fully human to begin chipping away at even the limited sovereignty we were granted, again, in cases like Worcester versus Georgia. And so I want to just point out a few key spaces in this opinion. So this is on page 8 of the PDF file. It's page 5 of the opinion. And it says here, but the general notion drawn from Chief Justice Marshall's opinion in Worcester versus Georgia has yielded to closer analysis. By 1880, the court no longer viewed reservations as distinct nations. Since the latter half of the 1800s, the court has consistently and explicitly held that Indian reservations are part of the surrounding state and subject to the state's jurisdiction, except as forbidden by federal law. Now, what Justice Kavanaugh is arguing here is essentially that as the nation grew and expanded, it began to interpret and define the relationship between reservations, native nations, and states and the federal government differently. And it's not because the treaties were changing. It's because the importance and the necessity of those lands and of these questions were becoming more important to white people. So the treaties weren't changing. The country was changing and SCOTUS was changing. And it wanted to, again, begin to diminish the small rights it even began to build. If we go down, this is on page 12 of the opinion. It's page 15 of the PDF file. It says, because Congress operated under a different territorial paradigm in 1817, 1834, it had no reason at that time to consider whether to preempt pre-existing or lawful assumed state criminal authority in Indian country. If we keep going down, it says, the history of territorial separation during the early years of the Republic is not a license or excuse to rewrite the text of the General Crimes Act. Again, this is reiterating the same thing. As the U.S. expanded, as the states became more and more solidified, populated, as the available land for Indian country to exist diminished, it's not that the treaties changed. It's that the way the U.S. interpreted those treaties and treated Native nations changed because now they had different needs. The nation had different needs. And they say, again, the second highlighted part, the history of territorial separation during the early years of the Republic is not a license or excuse to rewrite text of the General Crimes Act. So they're saying, even though it was this way when this act was written, and then over the years, we begin to change it. It's fascinating. So they're saying we can't change law we can't change law governing the nation based on the change in context and territorial separation from the early years of the Republic to now. But apparently, it gives you a license to reinterpret those laws, or better yet, even to rewrite or reinterpret those treaties. Again, the Native nations weren't changing, right? Our treaties weren't changing. The U.S.'s need and desire for our land and for the resources were changing. And so it began to interpret things differently. And as the needs of the U.S. changed, there was the necessity to legalize the diminishing of Native sovereignty and Native rights in these lands. If you go down to page 16 of the opinion, as well as this is page 19 on the PDF file, and this is addressing McGirt. It says, most everyone in Oklahoma previously understood that the state included almost no Indian country, right? And this is mind-boggling because the number of Native nations that reside in Oklahoma are high compared to much of the rest of the country. But after McGirt, about 43% of Oklahoma, including Tulsa, is now considered, again, this is merely for judicial purposes, Indian country. Therefore, whether the question of the state of Oklahoma retains concurrent jurisdiction to prosecute non-Indians on Indian crimes in Indian country has suddenly assumed immense importance. Again, the treaties didn't change. The importance of those treaties and the interpretation of the treaties changed for white people. This is what's changing. The treaties aren't changing. White people's need to remain in control changed, right? When you have maybe 5 or 10% of your state is considered Indian country, and now 43% of the state is considered Indian country, that's a lot of control you're losing, even with the limited understanding of sovereignty. And so the court's arguing, because the needs of white people have changed, we now have to redefine these treaties and how we read them in these laws, again, to be in our benefit. Okay, you have to remember the purpose of the Constitution is what? It's not to deliver justice and equality. That's not the purpose. It's to protect the interests of white landowning men. That's the purpose of the Constitution. And here the Supreme Court is absolutely making sure that white landowning men retain control. On page 19 of the opinion, this is page 22 of the PDF file, it says the exercise of state jurisdiction here would not infringe on tribal self-government. In particular, a state prosecution of a crime committed by a non-Indian against an Indian would not deprive the tribe of any of its prosecutorial authority. This is because, with exceptions not involved here, Indian tribes lack criminal jurisdiction to prosecute crimes committed by non-Indians, such as Castro-Huerta, even when non-Indians commit crimes against Indians in Indian country. See, now this is fascinating, right? Because it's basically saying this case is about something that we don't even allow Native nations to do in the first place, or even if we do allow it, it's in a very limited way, right? Again, when you have a nation whose constitution is written to protect white landowning men, giving up jurisdiction of criminal offenses of these white men to non-white governments is an abhorrent idea, right? Why would a white landowning male from the United States of America ever submit himself to someone else's court, especially the courts of savages, right? So again, it's already been fairly clearly defined, and this is a huge issue that Native nations have with U.S. law, is that we mostly don't have jurisdiction over non-Indians committing crimes, even against Native peoples, on our reservations. There's a few exceptions for that beginning to be made, but as this opinion points out, now what's fascinating about this is for this opinion, right, they are referencing a case called Oliphant versus Squamish tribe. And this is a case that took place in Seattle, in the Pacific Northwest area, regarding the jurisdiction of a Native nation over non-natives in their lands. And so up until now, Brett Kavanaugh has been arguing that we are not going to go based on the precedent of Worcester versus Georgia, and we're reversing that. But now he's taking the precedent set in Oliphant versus Squamish tribe, Sioux Squamish. I'm sorry if I'm pronouncing that incorrectly. What's fascinating is if you read this opinion, you will find that this opinion actually draws from Georgia versus Worcester. And so, again, this is what Brett Kavanaugh is doing is he's kind of piecing things together. He knows already what he wants to decide. He's taking pieces from different precedents throughout the history of Indian law, and he's finding arguments that fit his predetermined notion of what he wants, and he's piecing them together to build a legal argument. This is what he's doing. And so on page 20, they write that the state's interest in protecting crime victims includes both Indian and non-Indian victims. If his victim were a non-Indian, Castro-Huerta could be prosecuted by the state, as he acknowledges. But because his victim is an Indian, Castro-Huerta says he is free from state prosecution. Castro-Huerta's argument would require this court to treat Indian victims as second-class citizens, and we decline to do so. So here, Brett Kavanaugh is in a very condescending and demeaning way saying that he's taking the high road, right? Which is, if we saw the opinion, this case, the way our dissenters are seeing it, it would require us to treat Indian victims as second-class citizens, and we're not going to do that. And yet, the entire premise of Indian law that the two sides are arguing over, the entire premise of Indian law is based on the understanding that land title jurisdiction is based on discovery and the legal understanding that natives are savages. Neither side, neither Brett Kavanaugh nor Neil Gorsuch can claim the high road here, because the entire premise of the law, whether it's the blatant disregard for the law that Brett Kavanaugh has, or the diminished understanding of sovereignty that Neil Gorsuch is running with, both sides are absolutely dependent and based on, and don't even argue with, the legal understanding that discovery gives title to the land and that natives are considered savages. This is what's infuriating about these cases. This is what's infuriating about these cases. This is why it took me a week to even say as much as I'm saying today. And this is why I'm right. Both sides are claiming they have this high moral ground. And that's bullshit. Neither side presses the question, presses against the precedent of discovery, or against the notion of natives are savages. And again, we saw this very clearly. Go back right to 2005, right, when the case of land title comes up before the Supreme Court in Oneida versus the city of Sherrill. And again, footnote 1, they reference the Doctrine of Discovery. And in arguing the case, they basically make the same case that John Marshall makes back in the 1820s and 30s. John Marshall says, "But the tribes of Indians inhabiting these countries were fierce savages, whose occupation was war, and whose subsistence was drawn chiefly from the forest. To leave them in possession of their country was to leave the country a wilderness." 2005, the court argues, "Moreover, the properties here involved have greatly increased in value since the United sold them 200 years ago. It was not until lately that the United sought to regain ancient sovereignty over land converted from wilderness to become parts of city like Sherrill." They just didn't use the word savage, but they're building the exact same argument. This opinion on 1823 was written by John Marshall. The opinion in 2005 was written by Ruth Bader Ginsburg. And don't forget, it was Gorsuch in 2020 who wrote, "To determine whether a tribe continues to hold a reservation, there is only one place we may look, the acts of Congress. This court long ago held that the legislature wields significant constitutional authority when it comes to tribal relations, possessing even the authority to breach its own promises and treaties." So Neil Gorsuch, who is trying and is being framed as the hero in the case today for his dissent of Brett Kavanaugh, stated in 2020 that treaties with Native nations are not the supreme law of the land. Congress can break treaties whenever they choose. That's his stance. So please do not frame Neil Gorsuch as the hero of Indian country. He is not. Again, it's explicit versus implicit, right? We have Brett Kavanaugh and most of the conservatives arguing that, yes, we don't have to honor tribe treaties, period. And Brett Kavanaugh, or Neil Gorsuch, says, well, courts can't break treaties and states can't break treaties, but Congress can break treaties. So Congress can break the Constitution whenever it becomes convenient or necessary for them. One of the things that I'm feeling, I felt this for a long time. I feel, and this is just proving Native nations and Indian country is not going to find help in the courts. We're not. The Constitution was not written to protect us. It was not written to protect us. The precedents at the basic level of legal law in this nation is based on the lie of white supremacy and the dehumanizing of people of color. The courts are a horrible place to seek justice in the United States, because the courts weren't established to deliver justice, especially not to people who aren't white landowning men. So we have to find a different place to engage this. Well, there's direct negotiations regarding treaties. I'm not sure what the best solution is yet, but it's clearly not the courts. And as we've seen, right, not just with this opinion, but with the Supreme Court increasingly, not even increasingly, we need to start treating the United States Supreme Court as the partisan political entity that it is. We need to acknowledge Supreme Court justices are absolutely politicians with an agenda. And we need to understand that. Right? When you see Brett Kavanaugh literally going through a history of Indian law, which is already dehumanizing and unjust at so many levels, and then cherry picking a path that allows him to write the opinion he probably wanted to write in the first place, And then you see Neil Gorsuch dissenting, but not dissenting to the dehumanizing foundational level of the law, but just saying, well, we're not breaking these treaties in the right way. Again, Neil Gorsuch absolutely believes treaties can be broken without consequence by the US Congress. He just doesn't believe the court or the states have the right to do that. We have major work to do, my relatives. There's a lot that we have to figure out as a nation and as a country. And I think the thing that discourages me the most is that, and I'm going to use a partisan argument, Democrats have gotten Native nations to the point where we are willing to both celebrate and decry the giving or the taking away of these minute crumbs of justice that are occasionally thrown our way. And they've gotten us to take our eye completely off of the big picture. Which is, we were never treated as self-governing peoples in our own land. We were never treated or seen as equals. And there is no intention by either the Democrats or the Republicans to break that precedent. There's no intention. And so they get us whipped up into a frenzy when we get a crumb of justice from cases like McGirt, and then whipped up into another frenzy when that crumb is taken away in decisions like Oklahoma versus Castro-Huerta. And they've got us to completely take our eye off of the foundation, the sum of the game, which both parties absolutely buy into, which is that land titles are based on the right of white European Christian discovery. And for legal purposes, natives are savages. Anyway, that is my thoughts about this case. I will probably have some more thoughts. I was hoping this would be a bit more concise, but I kind of meandered a little bit. And I still have a lot of reading I need to do to fully understand the case. I haven't read Neil Gorsuch's dissent yet. I've read about it, but I haven't read it. And I need to go back and do more research on the actual cases that Brett Kavanaugh references throughout his argument to understand even more deeply the precedent that he does. One of the things I do now, whenever I read a Supreme Court case regarding natives, the first thing I do is I search the document. I search the opinion for the word discovery and for the word savages. It's the first thing I look for. I want to just understand, is this an implicit or an explicit piece of legislation that's being written here, or not legislation, the opinion that's being written here. And then you have to begin to understand the nuances, because we're not being as explicit as we used to be, but the implicit racial bias is still absolutely there. And neither side has any interest, as is proven by Ruth Bader Ginsburg as well as by Neil Gorsuch. Neither side has a desire to remove that implicit racial bias regarding discovery and the notion that we're savages. I hope this is helpful, my relatives. I see Dylan. I see your comment there, Dylan. You agree Gorsuch is wrong to not eschew the Doctrine of Discovery, but he's much more of an ally than the other conservative justices, in your opinion. That's the challenge, right? That's the crumbs they want us to celebrate. Is this thing becomes about baby steps. And baby steps are not about the agency and the ability of people of color. The baby steps are taken because white landowning men are incredibly reluctant to give up their power. And so when we celebrate their baby steps, instead of calling them out, we actually are helping them to retain their power. And Neil Gorsuch, his agenda is absolutely to retain the power of white landowning men. In not challenging at all the precedents. And he's trying to become the hero by getting us to celebrate the crumbs. Again, that's the challenge. And I'm not meaning to say this in a demeaning or in a dismissive way, but when we give white landowning men credit for taking baby steps, we are merely enabling them to continue to be oppressive. That's what we're doing. We have to call them out. We have to point out, no, this is no longer acceptable. We must address this at a foundational level. I appreciate your thoughts and comments. I know there's a lot of comments on here. I will go back and read through them, and I will try to respond to things that come up. I will definitely be talking about this again probably next week because there is so much in here. But I just wanted to share that with you. One other thing I wanted to share with you, if you remember, in the month of June, I was selling books on. I'm always selling books on my website, but for the last 3 weeks of June, I had said I would donate $5 for every signed copy of my book on Selling Truth that sold on my website. And I would donate $5 to help the victims and the families in Uvalde, Texas. And at the end of June, I had sold 28 signed copies of On Selling Truth on my website. And so I was able to donate $140 to the fundraisers going on for the victims and the families in Uvalde, Texas. This is just so if you're wondering where I donated, I used Gofundme. One of the things Gofundme is doing much more frequently now is when there's these mass events like these shootings that they know people are going to want to give to, they kind of have a verified space on their website where you can find verified people who are involved. So you can make sure you're donating in a way that they've actually verified is going to go directly to the people they're saying they're raising it for. And when I went to this page, I'm actually going to give you the link to this page in the chat section. When I went there, they had several pages, and I'll just show you what they had here. They had several sites that you could donate to. I believe there were 36 sites for the victims that you could donate to. because this shooting was so large, and not only were so many people killed, but a lot of people were injured in this. And then there are a lot of organizations that were raising money directly for this as well. The primary donation place that they highlighted on this website, and the one that I chose to donate to, is this one down here at the bottom, called Texas Elementary School Shooting Victims Fund. And there is an organization, a network called Victims First. It's a family of the deceased and survivors from over 2 decades of previous mass shootings. They started this fund to make sure that 100% of what is collected goes directly to the victim base, so the victims' families and those wounded and injured are protected from fraud and exploitation. So basically, it's people who have seen the exploitation and fraud that happened in the past. They came together and started this network called Victims First, and they collect donations and donate directly to the victims of that event, of that shooting. And so they had a fundraiser that was verified by Gofundme. It's raised over $6 million so far, $6.3 million. And this is the Gofundme that I decided to donate to. One of the reasons I did that is because I would have loved to have donated to each of the victims' families individually, but because there were so many, I would have only been able to give each of a few dollars, about $3.50 to $4, before I would have used all of the $140 I had set aside for this. And so that's why I chose to donate to that one right there. And I put the link for this page onto the comment section. So if you do want to donate there, you can absolutely do that. I also want to let you know I am continuing to sell signed copies of the book on my website. And if you are interested in purchasing a signed copy of On Selling Truths, you are more than welcome to do that. And I will put a link right here in the comments now. But I know this has been a longer one. I really appreciate everyone taking time to join me for the second cup of coffee. Indian law is both depressing and infuriating at the same time. And I try to represent this stuff as accurately as I can and with much understanding as I can. But I know I don't have everything grasped, even in my own mind, about this. But I wanted to give you my impressions as I read through this opinion and looked at the precedents they were basing their decisions on. So I hope you find this helpful. I appreciate the dialogue that all of us are having. Let me turn this off here. I appreciate the dialogue we've been able to have as on this page, and I look forward to the conversations we're going to have in the future. So, Yá'át'ééh, my relatives, walk in beauty, and may we learn how to walk in beauty together. Hakonet.